Hi, I'm Praveen. I'm membership and program director for ISACA Hyderabad. Today we have Mark. It's been very tough to get Mark onto this forum. Let me give a brief introduction. There's a lot to talk about Mark, but I'm going to give you a brief introduction, and then I'll hand it over to Mark. So Mark is basically a founder of Cybersecurity Excellence. It's an international cybersecurity training and consulting organization, and he plays the role of Chief Executive Officer there. And he has played many leadership and strategic roles in various industries like banking, insurance, government, pharmaceutical, healthcare, transportation, technology, and so whatnot everywhere. And he's also a cybersecurity thought leader by thousands of followers. I've been on social media. And he was also trained by IBM as AS400 and also worked with IBM Global Services Red Team. And in addition, he taught a third-year college diploma course in systems engineer, and also holds the certifications like CISM, CISSP, CISA, CGIT series. So the list goes on. And also he worked for Ministry of Justice Security, and I think I can talk about Mark all day. So, Vijay, I'll hand it over to you. Kindly welcome the speaker, and it's all yours, Mark. Then.
Hi, Mark.
Hi.
Sorry for the delay, and on a personal note, thanks for accepting my LinkedIn request. And it was a pleasure to have you. So with whole heart, we welcome you and hope for a good learning for all the members over here. And it's all to you, Mark. Thank you very much. Please carry on.
Thank you. It's a pleasure to be here. I want to thank the Hyderabad chapter for inviting me to come and speak. This is my first time actually speaking directly in India, although I have lots of followers from India, and I have many good friends from India, of course, who I know from LinkedIn, and I know from ISACA, and also I work with in Canada and the US, and it's great to finally really connect with India here on this call. So I'm so happy to have this honor, this privilege to speak. Yeah, I have lots of experience. I worked in 11 of the 16 critical infrastructures. So my perspective on cybersecurity, and today we're talking about privacy, is a little bit different than some other people's, but it comes from some experience, certainly specifically with GDPR and the privacy impact assessments. This is something that I have a lot of experience with, actually. Right now, some of my current customers are dealing with GDPR, and in British Columbia in Canada, where we have some of the strictest privacy laws in Canada, in fact, so strict that, for instance, Americans weren't allowed to come and view Canadian information. Canadian information wasn't allowed to be sent to the US. There's a lot of very tough restrictions that you don't see in other places, but in GDPR, we're seeing some of that stuff again kind of resurrect itself. So this is very familiar territory. I was a privacy and security compliance officer for EDS. And if you're not familiar with EDS is the second largest service provider. I guess they have like over 100,000 contractors really working for them, based out of Texas. So it's a very large organization. But I worked on Vancouver Island specifically for a $300 million outsourcing contract, which Bearing Point played a key role in, because the government was migrating their systems from legacy systems to SAP R3. We didn't have HANA at that time, but since then I've worked with some organizations where we've migrated or set up HANA HEC installation. Some of you might be familiar with those. Good technology, great to be a part of that process. Also been a privacy and security compliance officer in banking as well, with Central One Credit Union, which is the hub of the credit union system in British Columbia, with over 140 different brands being supported, including the big ones like Van City and Coast Capital. So you may be familiar with those as well. So this is not unfamiliar territory. I do have a lot of experience in here. And so I'm going to go through the GDPR implementation process, what I think it really needs to be focused and condensed. We're going to hear a lot of rumors from the lawyers. The lawyers have really jumped in on GDPR and certainly tried to take full advantage of it. It does require legal advice, I agree, but I think the focus on GDPR and legal is a little bit twisted. So I think for the technology people and the compliance people and the auditors, we need to have a slightly different perspective. It's not just about the law and complying with the law, but it's how do we operationalize legislation, and which is the most challenging part, right? It's okay, you wrote a great law, thank you for GDPR, but now how do we make it real inside of our organization? And so that's the kind of the part that that's my sweet spot, and that's what I'm going to talk about mostly. And the PIA plays a big role in that. The GDPR does have something like a risk assessment to identify personal information and do some kind of a risk assessment on it. But unfortunately, it's not very good. So while GDPR, the law, is very good with over 99 articles in it, their assessment of risk around PIA or personal information is not great. It's and this PIA process I'm going to show you is the one that we use in Canada, and it's much better. And so if you get the opportunity or you're currently working in a situation where you have a chance to work with GDPR in the implementation process, then I have some really good advice. Hopefully you'll listen to about using the PIA and leveraging it to make yourself look like a champion, right, when it comes to privacy and dealing with private information. So without further ado, can you see my screen? Can you see the slide I'm sharing?
Yeah, it's very much useful. Thank you.
Okay, great. Perfect. Okay. Now, if you have questions, I think if you have questions, you can probably put them through the chat. Is that okay?
Yeah, that should be fine. I think probably we can address at the last 10 minutes of the session kind of.
Yeah. And if you have specific questions about specific areas, put those in the chat and we'll circle back on them. Okay.
Yep.
And so how much time do we have?
We have 2 hours, of course. We can consider a full 2 hours of time from right now. So probably even if it is around 1:15 p.m. Indian time, that's fine. 2 hours from now is fine.
Oh, okay. We have lots of time then. Great. Because the presentation is about 30 slides, so it'll probably take about an hour, a little bit more to get through, and then we'll have lots of time to talk afterwards.
Yeah, that should be fine. Yep.
Okay, great. Thank you very much. Okay. So you've already heard about my bio. I don't want to go on and on about that. Lots of experience. Oh, my experience with IBM was on the red team, by the way, for 2 years. And there were 3 of us on the red team, mainframe, mid-range, that was me, and then a network guy. And we used to attack offshore financial institutions that were part of our sister company in the US. And 9 times out of 10, we'd be successful. Okay, so we're going to spend about 20 minutes talking about GDPR overview, and then we're going to talk about some key control areas in there. And then we're going to spend about 20 minutes also on the privacy impact assessment, and 15 minutes, or 5 minutes rather, to review any key controls in that area. And then we can do a question and answer period. And I know this is being recorded, so you will have a record of this, which is probably more valuable than actually having the slide deck. But I will send the slides over if there's something in there that you can use. Just give me credit where credit is due. That's all I ask. Okay, the GDPR regulation. So this is a really interesting regulation. It is pretty heavy duty, as most of you know. It's probably affecting all of us. I know it seems to be, even though it came into full force like a year or 2 ago, it seems to really, this year, there's a lot of demand. I'm hearing a lot of stuff about GDPR. So it's definitely building and building because it is rather complicated to deal with. And And some people don't know where to begin because there's so much emphasis on the legal spin on it. It makes it difficult to kind of get through the cloud and understand where do you operationalize this process, right? So there's 11 chapters and 99 articles. And you can see I built a little matrix to kind of summarize that because it's hard to put a full document in front of executives and say, here's what we have to do, right? So try to rationalize this a little bit. I went through the GDPR and this is my assessment of how it breaks down. So I think 1% of it is going to be about security architecture, right? And I know we hear a lot about privacy by design. You know, using a British term, I would say that's, you know, poppycock, because privacy by design is just, you know, it's just a subset of overall enterprise security architecture. Privacy compliance is about dealing with sensitive information. It's a particular unique set of sensitive information. However, if you deal with each legislation, each statute in a separate channel, what's going to happen is you're going to have a very expensive operations program for compliance, and executives are not going to be too fond of that. So you kind of have to rationalize this. So my perspective is 1% is security architecture, 2% is audit. Some of these things they don't come out and talk about in the GDPR. So this is my assessment of it based on my experience working with very tough privacy legislation and after reviewing the GDPR. 3% involves breach protocol, or 2% rather. You need to have some kind of a plan to be able to respond to breaches. And surprisingly enough, you know, there's so much focus again on, you know, creating the right schedules and articles for agreements with supply chain and contractors who are handling private information, and also with the privacy policy that you put on your website and how you collect consent and that type of stuff. There's so much emphasis on that. There's not a lot of emphasis on incident handling, right? So what happens when you have a breach? So the breach protocol is a very effective way to deal with that and get some traction. Be prepared because there's probably going to be some breaches. Okay. 4% is a business plan. So again, these are things that they don't talk about in the GDPR, but you need to have it. When you have a piece of legislation this big, you need to have a plan on how you're going to deal with it. And if you can write up a business plan that aligns it with the strategic and corporate goals and how you're going to achieve compliance with privacy, especially if you're an information technology company that solely deals with private information, you know, this is going to be a big to do. I was looking at some of the costs around implementing GDPR, and they range, it's a big range, it's up to $1 million for an organization in North America or in Europe. So it's a lot of money. So anything that you can do to help manage that process and make it more streamlined for the business and management team is better. Having a business plan on how you're going to do compliance is important. Data classification is probably 2%. You're going to spend some time creating a classification schema. You can't really, this is a big shortcoming with privacy by design, and also with the GDPRs. They don't talk about architecture and they don't talk about classification. It's all private information or nothing else, which is not really realistic inside of most enterprises, because enterprises tend to deal with 3 or 4 different types of information, right? So, and usually when I implement a schema, it's, you know, usually there's public information at the low end, and then there's confidential or operational information in the middle, and then there may be private information, and then maybe restricted, or maybe you'll just go with 3 different classifications. It depends on the organization and the culture. You got to see what the tolerance levels are in that organization in order to understand what's the best approach, because that's another thing that most of you, many of you probably know, is that the culture of an organization is held up very high in the corporate world, simply because culture is what has made them successful. So they're protected. It's like the crown jewels. So if you come in and you try to change the culture by implementing a really tough piece of legislation like GDPR, chances are you might get fired. So you have to have a really practical approach to doing this in order to sell it to senior management and get them to buy into it, because they know they have to do it. They're not sure how. So you need to be the architect for them, right? So classification is really important. You need to define the terms. This sometimes gets neglected. We do it in a lot of contracts. We have defined terms so both parties understand what we're talking about. But in the organization, you need to also have defined terms. That's my belief. It's 1% of the time, you know, making sure that everybody has a common understanding. What is personal information, right? A few years ago, the accountants from America and the accountants from Canada got together and they created a pretty good definition, and they actually separated. So they said, you know, super sensitive private information are like health records, x-rays, you know, that type of information really is very, very sensitive. Private information, sort of level 1 would be like banking information, right? And banking information, you know, the theft of credit card numbers and names and stuff used to be a big business, but it's not as big as stealing health information now, because of course, the way that the governments are organized, once you're a doctor, some of you may be familiar with this, some of you may not be, but once you're a doctor and you get accepted into a health authority, and so you work at your private office or clinic and you work at the hospital, right? Your signature becomes golden. So when you make an order, we call them doctor's orders, and you sign something to have someone have a procedure carried out, whether it's x-ray or surgery, or maybe they have to see a specialist or something, that goes into an insurance system. And as soon as they see that your signature has been approved by the health authority, then they just cash out. So they send cash to whatever the group is that needs to conduct the procedure. And that's how they allocate money. So that's why stealing health information has been a big lucrative business, is because people can take that information and they can fake a procedure of somebody and then collect the money on the other end. And nobody knows what happened until the poor person goes to see the doctor and they say, oh, how was that surgery or something? And I had a case of medical identity theft actually happen to me, because I have a very common name once, but it wasn't anything serious like that. And so the records get mixed up in the system, and nobody knows. So you should check your, you know, just don't just check your credit score, but check your health records too, to make sure that the data integrity is maintained. Okay, so back to defined terms. So having a common understanding of what private information is or what a breach is, very important. Governance is huge, okay? 35% of this is governance. So having some kind of a management steering committee made up of executives to make sure that when you're implementing these changes in the organization, that you have the support of the management team, very important. I've been around long enough to see all kinds of different scenarios happen. And having a governance committee is the best. Now, when I set up a governance committee, I use a government approach to governance committee. I have the CEO sign a terms of reference, and the terms of reference is a 2-3 page document that describes what that governance committee is going to be doing. So the inputs and the outputs. And then of course I name myself as the chairperson on that committee so that I can help guide the governance committee and what their responsibilities are, but also do all the prep work for all the meetings that we have. So this is important. Human resources is going to be involved. There's going to be changes because of privacy legislation, because of GDPR, and they're going to come from different angles, right? So you're going to have changes coming to maybe employee agreements. You're going to have changes, maybe operational changes to how human resources handles personal information. My experience is that human resources has always been ahead of the curve a little bit because they are so regulated when it comes to dealing with employees, whether it's hiring or recruiting or, you know, just the care and feeding ongoing of, you know, benefits and salaries and payroll. So that they've always been super sensitive when it comes to private information. So it should be an easy group to work with. The actual information handling procedure. So this is, even though it's 1%, information handling combined with classification is really the golden ticket when it comes to operationalizing GDPR compliance. Because Information handling is when you're going to be providing awareness training and communications. This is the subject that you're going to be discussing with employees in the front office, and probably to some extent the support team in the IT group as well. Legal, I've got them down to 6%. So they're going to be helping with the agreements and the contracts, and they're going to be working on the schedules, and they're going to be making sure that whatever we do, we're not exposed. But there's certainly, you know, GDPR compliance is not 100% legal. It's only about 6% in my estimate. Risk management is going to play a key role, of course. We need to have risk-based thinking when it comes to doing compliance. I don't think there's any other way to make decisions. You need to have evidence to back up what the decisions are, and you need to keep records. Yeah, but you need people to think in terms of what's the risk, what's the exposure, and based on that risk, how do we make a decision? Policy is going to be important. There's going to be new policies around personal information and the handling of personal information. Maybe 6% of your time will be spent on doing policies and procedures, and maybe 23% on procedures, because learning how to do privacy impact assessments, learning how to handle private information, whether you're in the technology support team or whether you're in the front office or a branch office of the organization. There's going to be some new procedures on how to deal with that information as it goes through the full life cycle. And there's going to be some standards. So, and again, this is something, these are things that are not mentioned in GDPR. This is based on my assessment, but you're going to need to have some security standards around how you protect information. And this is really, really important, because the legislation won't work unless there is some crossover with the security, real security, like encryption, and you know, how to effectively delete records and how to protect records when they're in transit or when they're being processed. So a lot of this information, these standards need to be defined, and then they need to be implemented in the organization. Some cases it might not be possible to do, you know, the level of encryption that needs to be applied, or maybe there's some, you know, some problems with encrypting the telecommunications, or maybe the database itself because of the way it's structured. So there might be some challenges in how you implement standards, but certainly you can create a roadmap once you do your risk assessment, identify, you know, the low-hanging fruit, those quick wins, get the quick wins, build some confidence with the governance committee, and then you'll be ready. You'll be on the path to compliance. And then finally, scope. So of course, scope probably could be number one actually on my circle here, but scope is very important, because, you know, what is the impact of GDPR? So is it organized? Is it organizational and wide? Is it enterprise wide? Is it just in Europe that we're worried about it? Is it just in Germany? Because I think Germany has the strictest approach now to privacy. So I'm not sure what the scope is, but you need to find out what the scope is, because scope creep is so bad. If you don't define the scope, then what will happen is you could run into scope creep. And if you're in an implementation project, and if you've led projects before, you know, scope creep can kill your project if you allow it to happen. So defining that scope, where do we implement? And maybe there's multiple phases. So maybe you start at head office, and then maybe you move GDPR compliance out to branches, or maybe you focus on your region first and then expand into the Middle East or Asia or North America. You know, it's lots of different options, but the approach needs to be defined. So that's kind of my overall analysis of GDPR. Most of the GDPR impacts are in operations, really, not legal. So the circle of trust is something that I like to talk about. Customers trust us with their information. There's a lot of decisions that go into making information. There is an information governance and accountability process, which should provide oversight. That's the outer ring. And then, of course, there should be information risk management decisions based on that. And when we think about all the different things that we could do with information? You know, how do we acquire it? When do we create it? How do we secure it, share it? How do we audit it? Pardon me. How do we maintain it, add, change, use, delete, archive it? Can we interface it with other systems? Not usually, right? So, you know, the consent to collect information has to be succinct with the purpose that you use it for. And sometimes this can be a bit of a challenge with some groups within the organization, depending on who you work with, because once you get that personal information in your hands as an organization, they like to, you know, leverage it and use it for as much as they can because it's extremely valuable. However, it's not allowed under the law, so you have to be careful about that, right? So whatever the reason is that you collect it for is the reason that you're going to process it for, and maybe it's going to be gone after you're done processing. Who can you disclose it to or share it to? Can you consolidate the personal information with other data? Probably not, but you might be able to. Can you migrate the data from one system to another? So this is a bit of a tricky question as well too, because organizations change and the data changes. If you're in the cloud, this might not be a question at all, but if you still have physical databases and you're migrating data from one system to another, you may not be allowed to, depending on what the consent was for that information. So that's something you have to look into. And also during the migration phase, you need to have the approval to migrate data from one system or one region to another. So, and if you don't have that consent, it can create some legal problems. So that's something to watch out for. Can you recycle it? In other words, can you reuse the data for something else? Probably not, again, because the consent has to be succinct with the usage. How do you delete personal information? You know, the right to be forgotten. Do you really delete it? Most systems, if you're a technology person, you know that most systems, when you hit the delete button, it actually just marks the record as deleted, but the record's actually not gone. And then of course there's all the backups and maybe multiple instances. If you're on a cloud and it's a cluster and it's around the globe, you could have multiple instances of that record in multiple regions. It's possible. So how do you delete it? And of course, how do you dispose of the equipment that was used to record that personal information? So what are the techniques they use? One of the things that we have to be careful of are supply chain problems. As you know, the NIST cybersecurity framework focused on supply chain. ISO 27001 focused on supply chain. There's a lot of discussion around supply chain risks. So making sure that you have, you know, flow down clauses that ensure that whatever the legal obligations are of the country of origin where you've collected this information from flow down to those other countries or other regions or businesses or subcontractors. So if you're not familiar, some of you might use flow downs already, but if you're not familiar, I'll just give you a quick description of what it does. So for instance, if you're a European country and you have to comply with GDPR, but you have offices in America or you have them in Africa or Canada or in Asia, the way that data works, the law only applies where the data sits, right? So it's based on political jurisdiction. So this can be a bit challenging, and this is why a lot of legislation says that you can't move my data from this country because they don't want another country's laws to be applied to their personal information. So what a lot of smart companies do in order to satisfy the customer's requirements is they take the law, for instance, they take the GDPR and they'll write it into a schedule or an article and they'll attach it to the master services agreement. So as you know, if you're experienced with contract law, although political laws, statutes and regulations kind of terminate at the political jurisdiction, contract law is international. So it's possible to stand up a contract with a company or a branch in another region of the world and make it stick because you can sue them, right? There's a possibility of suing them and taking them to court. Whereas if it's from one political jurisdiction collected, let's say in the UK, and then sent to China or Australia, you may not be able to uphold the law. So what you do is you take that GDPR and you write it into a schedule, you attach it to the MSA, and you get them to sign off on it. And now all of a sudden, the clauses in your flow down are, they match whatever the legislation is, right? Now the legislation could change over the duration of that contract, so there might need to be some amendments made from time to time. The other angle on flow downs that's important is that when you sign an agreement between the customer and the primary service provider, third party, if that third party goes out and they use subcontractors to do some of the work, which happens a lot actually, people don't realize it, that service provider has to make sure that that schedule with the GDPR clauses in it is written into the subcontractor agreement. So and now it flows down. So it flows from the primary service provider to all the secondaries through the supply chain continuously, right? So that's how that works. The other thing that we have to be careful of is there are a lot of interested parties in personal information. There's a lot of profiling going on of people. There's a lot of, in the banking business, you know, we have red flags and PEP lists, keeping track of politically exposed people is an agreement that we have with all financial institutions around the globe where they can be monitored. So if it's somebody from an area of, well, let's use Bin Laden as an example, for instance. So people were trying to find out where Bin Laden was many years ago. They finally did find him in Pakistan, but the way that they found him is by using PEP lists. So obviously the man needed to get access to money, and whenever he tried to use any of the banking systems, there was a red flag put up, and they said he's over here, right? So it's easy to track people. And the flip side of that also is that if you're politically exposed, if you're a political leader who the people love, but some people don't like because you created some problems for them, and it usually involves money, then you might be exposed to death threats or kidnapping or, you know, some kind of violence like that. Well, these PEP lists can also be used to alert law enforcement, right? So if all of a sudden you go missing and you're a politically exposed person, and we don't see any transactions on the account for a while, all of a sudden police get alerted and they go looking for you in the last place that you used your card, right? So it can be used a number of different ways. But the big point that I'm trying to make here is with all the good things that we do with it, there are some bad things too. So we have to make sure that, you know, that we don't allow unlawful information sharing, and that does follow GDPR rules, so that we make sure that, you know, we provide transparency and truth. These are the cornerstones of building a healthy relationship with your customers. Okay. Now I'm going to go over 4 steps to implementing GDPR. And the first one I'm going to talk about is the 4 simple steps. The first step is doing the privacy impact assessment. And later on in this presentation, we're going to go through that in great detail. So mapping GDPR legal requirements to existing enterprise private data handling, very important, okay? Probably one of the most challenging parts will be C, is mapping the actual data packets. And the reason why we want to do that is because sometimes packets, depending on the technology you're using, if you're using IPsec 4 or 6, right, you might be able to encapsulate the packets and protect them with encryption. Because we know some countries like China, for instance, they have the Great China Firewall, and they have rules about when you send data into China, it can't be encrypted. So I've worked with some customers like UK Mail, for instance, who was using a data center, a cloud service provider that had a data center in China. And when they found that out, they said, you have to reroute our data. We do not want it going into China. So they had to use IPsec6 in order to be able to address the packets and make sure that they didn't go through those servers or routers or across that firewall on the internet. So very important, but data packet flow analysis is going to be so important, and it's really a technical part of this whole process. So that's C. B, identifying and registering all instances of private data. That's going to be another challenge, and it's going to be really eye-opening probably, because before the law was in place, people would copy instances of private data and use them in different systems, not realizing that every time you use it in a different system, the purpose might change, right? And I've had some companies actually try and write the consent clause in a way that says that we can give, you know, carte blanche, full access to our company if we collect your information. But that's not the way the law works. So it's not advisable to do it that way. You want to collect it for a specific purpose, some type of service or product that you're providing. And so when you look for these instances of private information inside the company, when you do your flow analysis, tracing it across the infrastructure, and then looking for the instances of where you actually have a database, a duplicate, another instance of the same personal information that was collected, then you're going to have some tough discussions actually with the management team on why you're doing this. And now what we have to do, we have to go back to legal and we have to ask for consent, because we never asked consent for this before. And of course, the flip side of that is if you don't get consent, then you have to stop using it for that purpose. So it's not going to be always easy discussions, but you won't know about these things until you actually do the analysis and find out where it's at. And that's all part of the privacy impact assessment. And then finally, D, identifying the risks and potential exposures. Again, we're putting on our risk management hat, and we're doing some risk analysis and thinking, you know, where are we exposed? So some technology has to decrypt or unpack encrypted data in order to process it. And so you have to be aware of the type of technology that does that, because as your data, your private data packets flow across the infrastructure from the internet or from other branches, and then across your infrastructure, your WAN or your LAN or VLAN or whatever it is you have, or your cloud, you need to know where that data is going, and you need to know if it's being unpacked or encrypted, right, while it's traveling across those devices, those appliances, whether they're routers or switches or firewalls or load balancers. You don't know. Every hop inside your network is a potential area for someone to do add a sniffer, Wireshark or something, sniff the traffic and collect data, or maybe put a tap in and mirror the data and just create a complete duplicate path for that data. So I'm not saying that we have to be too suspicious of our teams, but they may not know. So let's just say, let's chalk it up to innocence and not understanding the implications of GDPR and what it means when we have this data flowing across our infrastructure, what the implications might be for the security architecture. And, you know, privacy by design can't go to this level. We're talking about enterprise security architecture now, purely. So step 2 is to operationalize compliance. And the best way that I've seen is so simple, it's just mind-blowing, right? Creating a data classification schema, getting the governance committee to accept the schema, also the definitions of what personal information is or what a breach is. Very, very fundamental, so simple, but very, very important, because a lot of stuff gets driven from these decisions. The schema will help define, it provides a balance within the organization. We're not just going to say we're going to focus on GDPR data, not just personal information, because we have a whole bunch of data that we collect. And if you're going to implement a classification schema, you need to address all of that information and how you deal with it. So that's going to be very important, because you're changing the culture. This is really a bit of an evolution, digital transformation, if you like, of the organization from being a much less secure to a more secure environment that our customers and partners can rely on. Creating security standards is a very important step for private information. Again, GDPR and privacy by design, they don't touch on these things, right? These are things that we need to do as professionals. We need to work with the engineers. But first, we need to look at the infrastructure and the assets that we have and where that data is hopping across, right? And then we can create some security standards around how we can protect that. That's the smart way to do it, okay? If you come in with a very hard approach and you say, okay, here's the highest level of encryption, everybody has to follow this, right? Your infrastructure may not be able to support that. So my advice, based on experience, is that do your research, find out what your infrastructure equipment looks like, build a security standard that you can implement today, and then build a roadmap for where you need to be, and then follow that roadmap, right? And make sure the governance committee is on board with that and agrees to it and supports it, and then report to them on a regular basis on how it's going. So you get your security standards. So you get your schema in place, you have your security standards in place that talk about the type of encryption or the type of handling. And then you talk about creating a private data information handling procedure. So what is private information in your organization? What does it look like, right? Is it health information? Is it banking information? Is it just, a user, a customer's name? And this can be a little bit tricky too, but the information handling procedure is how you operationalize compliance with GDPR at the office level, so at the front office level. Without this procedure, it's going to be a bit of a cat and mouse game, and it's not going to work very well. And there'll probably be lots of problems. And then, of course, creating the flow down clauses, very important. I talked at great length about that already, so I'm not going to jump into this any further, but you understand, if you have questions, about any of this, you can always ping me and ask me, and I'll try and help you the best I can, okay? I'm not a lawyer, by the way, so I can't give you any legal advice, but I am a professional with a lot of experience. 3, develop data protection skills and resources. So we want to develop awareness training, and that all begins when you create a data protection standard and a schema, and then you create an information handling procedure. Now you got to somehow bring the enterprise employees and managers up to speed. Usually whenever I implement anything that's going to create some questions with the employees, I start at the manager's level, and I usually create an FAQ, and I do a little awareness training with the managers just to let them know that you're going to get questions, and here's how some of those questions are going to probably sound. So I usually use a Kepler-Ross curve, if you're familiar with that, because change within digital transformation or change within any organization goes through a flow, right? Where, people at first don't want to change because they like things. Humans like things to be the way they are today, consistent, because they don't want to have to learn new things. They don't want to have to do new things, right? So some people are kind of lazy like that. But gradually, if management keeps communicating and you pursue your goals, they will start to come around. It'll take time. But when you develop the FAQs for the managers, you want to make sure you prepare them. So if you have an employee that comes to you and says, no way, I don't want to do this, your FAQ needs to be able to address that, right? You know what, this is good for the company, this is good for business, we're all going to benefit from this in the end. So, and it's just part of change, and we have to keep evolving, because if we stay stagnant, our competition is going to take over. They're going to change instead and take over our market segment. So we need to make sure that we're changing. So you need to have conversations like that, and you develop FAQs around that. And that's all part of awareness training in digital transformation and getting people on board and improving their skills. How do you recognize personal information if you see it? What happens if somebody asks you for personal information, but they're not authorized to have access to it? How do you deal with that, right? So, especially if they're a colleague or a friend and they're working in another part of the business, it happens. In the health sector, We have systems actually that monitor for this. And a lot of systems, if you worked in health authorities, you understand that the systems have to be wide open, almost, right? It's almost like a university campus, right? Where there's very little security control because doctors need access to medical records of people in order to be able to give the right diagnosis, the right prognosis, to help them to get better. If they don't have that medical history, it's kind of a shot in the dark. It's not that a doctor can't do that, but there's a little bit more risk involved. So these medical systems are wide open. And one of the problems that they have with health systems because of that is because if you do have curious people and someone who's famous comes into the hospital needing help, a lot of times you'll find people will log into the record and find out what they're doing there, right? Very unethical, kind of nosy kind of behavior, but it does happen. So, and the same goes with family members, right? So if someone works in the health sector and they have access to health information records, they might try and look up a relative who's getting treatment for something to see what's going on. Now, these are all totally unethical activities, but they happen. And because of that, some health information systems have developed sort of auditing type software. So they see the medical professional's profile and they see who they have access to. They check the you know, what patients that they've been assigned to look at. They also check, you know, family names to make sure that you don't have the same family name as the person you're looking up. So they do things like that. And then of course they kick out reports because we need to know about who these people are in order to have a lot of chat with them. But at the same time, it's necessary. And I don't know that we have this capability yet in the financial sector, but it wouldn't surprise me because of rules like GDPR that happens if it has not already happened. Okay, so enough about that. So data protection skills. So we want to develop, we want to improve the skills, how to identify personal information, how to handle it, how to secure it. So that's important. That's step 3. And step 4 is to verify and validate. So of course we're going to do privacy audits, right? We're going to go back, and the best way to do a privacy audit is if you have a privacy impact assessment that maps how the organization has complied with GDPR. And that's very important. Okay. So a little bit of a workflow. So if we have an employee who wants access to information, they need to verify entitlements. Usually it's with the employee's manager. They have a job description. They have some kind of responsibility to handle personal information, and they should have entitlements. If they don't have entitlements, then they shouldn't have access to it, or the job description is out of whack. Usually these kinds of decisions, what groups within the organization have access to what type of information, needs to be verified with a data protection officer or some kind of a designated information owner. So in the ISO world, we assign ownership to all of the assets just so that we can begin the governance process. And then of course we follow up with it. In GDPR, they look for data protection officers. In the privacy legislation in BC, for instance, you have to appoint a privacy officer. So it's usually a privacy compliance officer, and sometimes they combine it with security. In my case, they've done it a few times. Then the information has to be labeled in some fashion, ideally private. If you're not sure what the classification schema is, you need to talk to whoever it is that's responsible for security, for enterprise security. It could be a CISO, it could be a chief cybersecurity officer. And then you can also verify that with the data protection officer, because the CISO and the DPO should have had many conversations together about how they're going to protect the enterprise private information. So they should be on the same page. Then you apply security standards. Now, security standards usually get set with the chief cybersecurity officer or the CISO, who works with, again, the engineers to see what can be done, what can't be done. when it comes to encryption, what's our path for the future, and then authorize access. And should always keep a record of any requests for personal information, because this is an auditable process and it should be audited on a regular basis, as I mentioned in the step 4, the previous page, that we want to continuously do audits of this information. Maybe an electronic audit, maybe the kind of system that I described at the health authority, maybe a manual audit where you sit with people and find out what they're doing. Could be a combination. Okay, so I've provided several documents out there. If you've subscribed to my YouTube channel or Vimeo, which is where I'm trying to push most of my videos now on anything that has to do with awareness or training, you'll find a schema. So I have an example of a schema written out there. I also have a security architecture described out there, and security standards listed on the different types of activities and how that's structured. You can find that information on Vimeo. Some of this is not on YouTube. You have to go to Vimeo for it. And of course, authorizing access, you know, the importance of documentation, you know, strategy, policies, procedures, standards. They all need to have records. We need to maintain records so that they can be audited. And I'm sure the ISACA people are going, yay, auditors, right? Because auditing really has kind of taken a back seat with all the growth in the cybersecurity area, but auditors are so important. And I emphasize this with everybody. You know, I'm old enough to know that before there were enterprise architects and data scientists, if somebody in the company wanted to implement a new process or procedure, the first person they would probably visit is internal audit, because internal audit has the privilege of being engaged with everybody in the organization. And very much like an enterprise architect, they know where the data flows and they know what systems there are. So if you want to implement a new system, there's no better person to talk to than an internal auditor. And unfortunately, that hasn't been respected, I think, over the years, but it's still true. Internal auditors are so important for every organization. And then, of course, there's the 4 steps that I mentioned before, and now you have more details because it's been recorded here. So you have some more information on those 4 steps and how to get past this. And we're going to talk about privacy impact assessment soon here. So this is a quick snapshot of a 4-tier classification schema. So we have public, confidential, private, and restricted. And I won't go into the details. You can read the slide when you have time, but I will go over the thought process here on why it's 4 tiers. Okay, so public information is marketing material, basically, or anything, job postings, maybe when you want to recruit or hire somebody, right? So it should be distinguished between the other types of classifications. Confidential information is what we use inside of the organization in order to run our business. Private information is really, just like it says, it's, you know, it's usually employee records or customer records. It's something that's private. And then restricted, that's the highest level. So these are the mergers and acquisitions. This is the organization's plans for IPO or strategic planning and market growth, right? And this information should be only accessible to a very limited group of people. Now, if you're a security architect and you understand the way that systems are designed, so most systems today, probably 98% of the systems designed today, the way the databases are structured, they're not structured for a GDPR process. Because if you wanted to do it properly, you'd have to restructure the databases. So because they're not going to probably do that, they're going to restructure the applications in ways and configure them in different ways in order to filter access to information. And the reason why we have it as public, so public, we're not too concerned about security. Confidential, we need some security, probably commercially reasonable security. Private, we need a little bit more because we need to restrict everybody that has access generally to confidential information. We need to restrict it to only the people that have authorization to the private information. And of course, restricted is even higher level. So as we go up the schema, we have more and more security architecture in place. So we can't put more security architecture at the low end of the system, because it will restrict everybody that wants access to confidential or private information. So it has to be at the higher level. So it is very much a tiered type of architecture approach. Okay, so some examples of the classification or the security standards rather, pardon me. So in this version, it's a combination of manual, like human processes versus automated built into the technology processes. So in some cases, this is why we teach people information handling, because we want them to understand how to identify this information. It's also a good continuity process in case your systems go down. So when it comes to granting access, for instance, it should always be up to the designated owner or the DPO who has access to the information. When it comes to authentication, public, of course, has no restrictions, but under confidential, private, and restricted, we have some various security standards that could be implemented. So we want to have some kind of identity and access management system, two-factor authentication. Maybe we're using RSA tokens, public key infrastructure. We want complex passwords. Same stands for private. Instead of 2FA, we're looking for multiple factor authentication. That's the only change there. And then under restricted, we're moving even further from complex passwords to actual biometric, some kind of biometric scan in order to identify people. So you can see that the security is increasing as we go to a higher level of classification and more restricted and limited use or access, pardon me. Transmission over the internet, no restriction. However, under confidential, we might use SSL, TLS, or Tor. Under private, we could use the same plus maybe VPN. Tor is actually a version of VPN. It's just split tunneling, so it's a little bit different. Plus, if you have wireless access, you want to consider WPA2 when you're accessing the internet. Restricted information, we don't authorize you share that on the internet because it's so important to the lifeblood of the organization. It should be safely guarded. And I'm not saying that private information shouldn't be safely guarded. I'm just saying that private information won't matter if the company goes bankrupt. So you need to really protect that important information, the patents, and any kind of growth planning for the organization. And the executives, when you present this to a steering committee based on senior managers, top level managers, they look at this and they think this person has a good approach. This is very practical, and they say, they understand that we're in business for a purpose, not just private information. So we don't put private information above what's important to the organization. When it comes to storage on servers, again, public information, we want people to have access to it, so there's no restriction. If we have marketing brochures or campaigns, we want people to spread it around. Confidential information, we may use AES 256 or RAID 5 on the servers. We may also, on private information, we would use these, plus we would use TPM by Microsoft or Vernem or SAP HANA are additional layers of encryption. But the things that these provide, these types of technology, is that you can actually encrypt the data on the chip while it's being processed. So we take it from the old days when we can only encrypt the disk to now we're encrypting the telecommunication path and also the chip. So, and SAP HANA has done some great stuff in this area, but I'm not discounting TPM or Vernem. They've also done some great stuff, but I'm just more of an SAP fan, that's all. And the same applies here, of course, for restricted information. So that's storage on servers. Removable media, no restriction. AES 256 under confidential or sorry, public key infrastructure. And for private information, storage on removable media is not advised, right? I know how hard it was for people to adopt and to adapt to the privacy legislation that first came out in British Columbia. We had a lot of restrictions on systems. And in some cases, in really top secure environments, maybe you've worked in, some of you, they use thin clients. They don't even have devices that you can do any of this stuff on to store information, right? So they make sure that it's all kept on the host or the server and not allowed to be. But still, under privacy legislation, it's not just a matter of having a copy of it and the potential of unauthorized disclosure from having that copy. Even just simply viewing your screen. If an unauthorized person walks by you and is doing some shoulder surfing, that can also be an exposure. So when you educate people and you do your awareness training, you may also talk about mobile computing as well, and some of the challenges or risks around mobile computing, whether they're sitting at home, which a lot of us are doing because of the pandemic, working from our homes, or whether you're in a coffee shop or some other public area. You know, it's the responsibility of the person to make sure that if they're viewing personal information from some kind of remote location, that they keep it safeguarded. Transmission over email, again, no restriction for public. However, confidential enterprise to enterprise encryption is advised, 2FA, A+ SSL certificate. Maybe you have a data loss prevention system in place, or DANE as well. And of course, for restricted or private, it's not authorized. So sending private information over an email system can be a problem, for sure. And disposal, and these are all options, so you don't have to implement all of these options in your infrastructure, but this gives you something to talk about with your team, right? What can we do? What can't we do, right? When it comes to disposal for public classified, there's no restriction. For confidential, cross-cut shredder is advisable. Sometimes you have shredding boxes and you have people that come in and do the shredding on a monthly basis or something. They'll use a cross-cut shredder, hopefully. If you're going to overwrite it, it has to be at least 7 times, or it can be recovered. And that's been proven through forensic examiners. And also metal shredder. So in BC, for instance, when I got there as a privacy officer, about 2 years before I arrived, they had a big problem. So the government has these desktop computers, and they're upgrading, of course, and they don't want to throw them away, so they resell them, not on eBay or anything like that, although that has been done, but they resell them through the local libraries or something like that. Someone picks up a couple of these, and they do some forensic analysis, and they pull out all of these citizen records off the disk. So when that happened, there was a complete knee-jerk reaction, of course, by the government. It's typical. And the government started warehousing all their surplus equipment. So when I got there, there was warehouses filled with desktops, and old desktops, and they didn't know what to do with them, right? When I first got in BC government, I worked in the information security branch as the manager of compliance assessment and reporting. And my 5-person team, we actually created the data destruction, the media destruction policies, and rolled those out while I was there, in addition to doing some other stuff. But and when that happened, we started using a metal chipper. So ultimately, the metal chipper was the way to go. And here's the funny twist to that story. So if you've been in Vancouver or BC, you see these things, they're called spirit bears on the sidewalks, or eagles, right? They're these composite artistic sculptures, and the particles in the sculptures actually come from those metal chippers, from the private information. So because BC is so green and they always want to reuse stuff, when they were done metal chipping all the servers, they sold it to the First Nations people who created these spirit bears and spirit eagles and stuff. So it's kind of a funny story. Anyway, so let's move on. So some key controls. Information protection management system for sustainability. So you need to have some kind of a management system. Needs to involve things like architecture, audit, breach protocol, business plan, data classification, defined terms, governance, human resources, information handling, legal, risk management policy. And if you're sharp, then you'll realize that all of these key controls are things that I mentioned in my pie chart when I did my analysis of GDPR. And I said, you know what, if you want to have a proper privacy protection system, here's the parts that need to be built into that. So those are the key controls. You need to do a privacy impact assessment, and we're going to talk about that in a few moments. I'm not sure how our time is going, but I suspect that since we had 2 hours, I think we're okay.
Yeah, of course. Please continue.
Okay, great. Thank you. We're going to talk about you need to do data packet flow analysis. This is really a bit of it's a job. It's not easy to do data packet flow analysis in an infrastructure, and the larger the organization is, the more difficult it's going to be. We need to do risk assessment to support the privacy impact assessment. So privacy demonstrates compliance with the principles of GDPR. Risk assessment shows how we're going to secure it. Information classification schema needs to be created with security standards. And cybersecurity architecture, we talked about privacy by design. That's been floated out there by many people. Privacy by architecture is another concept, but ultimately you're going to end up with that that cybersecurity architecture model that I showed you. Okay, so now we're going to jump into the privacy impact assessment. And this workflow is terrible, so I'm going to skip past this, but if you have access, you can, maybe I can give you a high level kind of perspective. So when you initiate the process, the first thing you want to ask is, has a privacy impact assessment been done for this system? So privacy impact assessment is a way of measuring compliance with what you're doing as an organization against the GDPR principles. A privacy impact assessment is also a living document. So for every instance of private information or personal information that the organization has stored on its servers, there needs to be a privacy impact assessment. How did it get there? What are we using it for? That type of stuff, right? Needs to be answered, those questions, okay? That becomes a living document. So unlike an audit report or a risk assessment or an audit report are sort of a point in time report, if you know what I mean. So we came here in July, or we came here in March, we did a review of the system. Here's our report, right? And it tells us where we are in that process. But a privacy impact assessment is attached to whatever the personal information is that we've collected. So if anything changes with that information, the privacy impact assessment needs to be updated. So it becomes a living document. It's a record of, again, of how we comply with GDPR. Very valuable piece of a report. It's a compliance report. The questionnaire. So the following questionnaire was designed, privacy impact assessment. It provides a lot of value, talks about how we use private information. This is the actual definition that the American Institute of Certified Public Accounts and the Canadian Institute of Chartered Accountants came up with. And I know there might be some accountants in the audience since we are ISACA. But I thought it was very interesting when accounting firms came out with a definition of private information. It's a pretty good one, so I use it. So it's a little bit of fun. They do have two categories here. So they have private information, less private, like name, address, social security number. These things are obviously need to be protected, but they also have a sensitive. So they distinguish again. So it's important, I think, to have a little to distinguish. You know, is a social security number important? or as important as maybe your medical conditions, right? So, or your racial or ethnic origin, right? Like this type of information is can be used against you, right? Can be used to exploit your information, to make money for organized crime. So this stuff is really very, very sensitive, and it shouldn't be in the same file. And if it is, it needs to have another lock added to it. So there's two categories. The principles are like this. So lawfulness, fairness and transparency, purpose, limitation, data minimization, accuracy, storage, integrity, and confidentiality. That's kind of where the security comes into. And then accountability. Those are the principles. So when we look at lawfulness, we're going to ask some questions. And the answers to these questions begin to fill out your privacy impact assessment. So was the consent clearly linked to the purpose for the collection and usage? Important question. So find out where the consent is. You're going to have some challenges with consent because if the company is new to GDPR, then they may not be collecting consent in the right way. And this is something that we've gone through, you know, like a decade ago in British Columbia when we had to have consent. And for every record that we had in our database of personal information, we had to have a matching consent. So they had to be reconcilable, right? Which is, the accountants will love that because I love reconciling data. It's a good part of data science to make sure that we have good data. But collecting the consent needs to be kind of thought over. Now I have talked to a group actually in Turkey a few months ago who are working on a tool, and I'm sure there are other tools that's just going to focus on gathering consent and managing the consent as the data changes, which is kind of an interesting approach to dealing with that problem. But it can be a problem if you don't have consent and you have the record in your database, then it's kind of like unethical and you've collected information from some clandestine approach because there's no consent, right? So you need to have that consent. Did the consent clearly and unambiguously specify the personal identifiable information that can be collected, used, or disclosed? So it has to say, you know, here's what we're collecting, here's what we're using it for. Does it need to have a data field specification? Maybe not. Does it have to have, any kind of a field layout specification? Probably the person doing the PIA wants to ask for that to make sure that you have a record of what data you did look at. Did the individual implicitly consent to the collection of the personal information? So this is important because this is a bit of a trick, right? So you have to actually have consented. You can't, the company can't assume that you've given consent because you took a certain action, right? So maybe you clicked on the front page and they said, you know what, we collect information about your I guess access to our network. We have, we're tracking people who access our network, and somewhere in that there's buried a consent to collect personal information, right? It has to be pretty clear. This is your personal information. We're about to collect it. Do you agree? And if you click on a box and then that box is captured with a consent form and stored in a database somewhere, then you have a record of that. What's personal information, personally identifiable information? And I talk about PII a lot because that's kind of how we define it in Canada. Collected indirectly from an external third party. So this is a no-no. But it's a good question, a valid question for an auditor to ask is, okay, so if you don't have consent from this person, was it collected from a third party? Because if it was collected from a third party, maybe that third party has consent, and let's hope that that third party also has an agreement in that consent to share with you, because if not, then you have a database that you have personal information and no way to prove that you have consent to collect it, which is not good if GDPR people come looking. Okay, 2, purpose limitation. So is the business purpose for collecting using the information? Is there some kind of a retention period? Are are they going to use it? Can't collect someone's personal information and say we're going to collect it forever, unless you're a government, right? Because that's kind of what they do. But if you're a business, then there's probably some kind of a retention period. So like PCI, DSS, they collect credit card information during a transaction. Once the transaction is done, credit card information is tossed, right? Not allowed to keep that information. So the same goes with all other types of personal information. Maybe a health authority, they might collect it and maintain it for a long time. Maybe in their privacy policy, they say, you know what, until the person is deceased, no longer live, we're going to keep this information. And we might keep it after that because a lot of those companies share information with researchers. So that's the other thing you have to, you know, examine when you do your privacy impact assessment is what third parties are you sharing it with? Are the researchers involved? Because some legislation has exceptions and clauses for research, because without personal information collected through health authorities, the people who are doing research in labs or in universities on different types of diseases or different other things that could help society, they need that information in order to improve health care, in order to improve the lives of people. So they might need to share that. So it might be a valid third-party sharing, right? But it needs to be documented properly. And there needs to be some kind of retention. All right. Has the purpose for a collection been mapped to the business purpose? So this is important. We just want to be able to sync up with, you know what, whatever it says in the privacy policy, when they click, yes, I consent, that matches to whatever the business purpose is. Has the purpose for collection been mapped to a specific statute or regulation? So it's possible that GDPR might give some exceptions to different types of legislation. I think there are some exceptions. I know in BC in the privacy legislation there, you know, for the purpose of collecting money, for the purpose of law enforcement, there were some exceptions around it. So if law enforcement was looking for somebody, it's possible they could come and ask for information. So we need to make sure that it's whatever the regulation is that gives that exception, that it's mapped again and documented in the privacy impact assessment. Like, what are the exceptions? Is the purpose for collecting based on an exception due to debt collection, investigations, or media? I think I just talked about that. Okay, data minimization. Can the requirements for the collection be limited or reduced? So this is important because, again, in the past, when you went to apply for a loan from the bank or insurance from an insurance company, they over-collected a lot of information. And they did it on purpose because they have actuaries who require additional information in order to determine if we should write a policy or we should grant the loan, right? So the more information they collect, the better. If you go to Equifax, for instance, they have collected a lot of personal information about not just Americans, but about all different nations. Anybody that has a credit card, Visa, MasterCard, your information is being collected in the US. And if you ask for a consumer report on your private information, you're going to find out that from the first day that you collected, that you opened a bank account to current time, that everything, anytime you've ever asked for credit, will be listed in the consumer report. So if you bought a house or bought a car and sold it, it would be listed there. If you have children and you sign for their bank accounts, it would be listed there. There's so much personal information in Equifax. It would scare most people. So, but can you minimize the collection? So, you know, the less information that you have, the less exposure that you have from a legal perspective, from risk. If you have less information and you get breached, then there's less impact, right? So maybe it will cost the company less if you get breached. You have to think about it in different kind of terms like that. But the most important thing is make sure that whatever the reason is that we're collecting it and the type of information we're collecting it is for a specific purpose. And on the flip side, make sure that they have enough information to do the job that needs to be done with that personal information. It's personally identifiable information collected directly from the individual. And this gets back to my earlier comment about, are we collecting it from a third party? Do they have permission to share it with us? So that's very important to check in information sharing agreements. It's personal information indirectly collected through other programs. So if you're in the government and you have multiple ministries, you might have 19 different ministries. You have, Department of Transportation who's collecting driver licenses. You have Department of Health who's collecting health information. You have, the revenue people who are collecting tax money. They might all be sharing information. You might have a master record somewhere of your whole life in that country or in that province or state, recorded in the government. So, but how did they get that information? Did they collect it? And earlier when I talked about the circle of trust, I talked about, unlawful ways of gathering information. So some of these ways that they share information goes beyond privacy legislation. However, the privacy legislation, GDPR, doesn't have any sort of grandfathering clause. So you'll notice that when you read it or your lawyers read it, you don't get, because you collected personal information before GDPR was published and became enacted, doesn't mean that you have, a get out of jail card, get out of jail free card in your back pocket. That doesn't exist. So when you've collected the personal information, you need to follow the GDPR. And if you've collected it through other programs or before that date, you need to also go back and get that consent again. 3.4 is PII collected indirectly through external parties. So there's a number of different types of collection. So we talked about collecting directly from the individual, collecting through other programs in the organization, or collecting from an external party. And it's possible. So for instance, if you're in the finance business and you grant loans or you manage credit cards, then you're going to probably be, when you do the approval process, you will be running an inquiry into Equifax. And in exchange for that inquiry, you'll be collecting maybe that consumer information from Equifax for your own records. So now, does Equifax have the authority to share your information? Probably not. But you want to read the fine print on your agreements also with whoever it is that you're getting loans from. And on the flip side, again, if you're in the business side of things, then you want to make sure that your company does have the proper consent in order to collect this information from a third party. And if the third party is collecting the consent and you don't have the consent, make sure that you have the authority to pass that consent to you. Accuracy, so data science, are the records accurate? Very important. Consumers need a way to maintain their records. Are the dates and the timestamps for the user accurate? Transactions accurate? This is really important. Some of us monitor our credit reports, and the reason why we do that is because if your identity is ever stolen and somebody else uses it, you have a limited amount of time to report it before it becomes a permanent part of your record. So you want to make sure that your data is accurate with whoever it is that is sharing this. Have procedures been documented and communicated to customers regarding access and maintenance to inaccurate records? So this is really important. Usually in the privacy policy, we have a statement in there that says that if you have any questions about your records, contact the data privacy officer, or data protection officer rather, or the CISO, or maybe legal. So they have to be able to contact somebody. That has to be in the policy. Our records kept regarding requests for access to records. So this is kind of funny. So every time you ask for a copy of the records that a company is holding on your behalf about you, they probably record a request for that. A classic in this happened in Canada, of course. classic way of dealing with this, because there are costs to the business associated with all this record keeping and record management, and somebody has to pay that. So in Canada, after a few years of the privacy law being in place, they decided that they're going to actually send the bill back to the consumer. So if you ask for records, then they're going to say, well, okay, if you want your records, it costs us some handling fee. So, you know, pay us $25 or whatever. And, but to the point of this, there'll probably be records. Anytime somebody makes an inquiry, you'll see this on your credit reports. Actually, this is a classic one. So every time somebody makes an inquiry on your credit report, it actually puts a hit on your credit. It drops your score down. So it's really important to understand if there are records kept and why. Can consumers access their personal information without disrupting regular operations? That's a good question, a valid question to talk about accuracy. If you have databases sharing different parts of your information, and you need to make an inquiry and ask what records do you have, does somebody have to stop what they're doing and go and collect that information? Storage limitations. Are there specific statutory regulatory obligations for retaining personal information? So why are you collecting it? GDPR governs the process of handling the private information, but why are you collecting it to begin with? So do you have the authority to collect it? So if you're in government, a lot of the ministries actually have a specific law that creates the ministry and the reason why the ministry exists, and it describes what kind of information that they can collect, how long they can retain it for, and what it will be used for. So every government ministry has these laws, not so much with corporations. So the privacy impact is really important in order for you to be able to prove the reason why your company has collected this information, is using it. It may not just need to comply with GDPR, but there may be some other regulations. There are literally hundreds of regulations to apply that to every commercial enterprise. Which ones of those impact the type of information that you collect? So you need to look at that. So for instance, if you have employment standards regulations, you have to collect some type of employment information, right? If you have, pardon me, CRA or revenue laws that might impact how you collect information or how you retain information. So it's not just about GDPR, but there's going to be some other laws probably that come into play, and you need to find out what they are. The legal team might know, they might not know. They might not want to talk about it. Some lawyers don't want to make a list of the regulations that a company has to abide by, simply because once you document it, it means that you have to comply with it, and you can't pretend that you didn't know about it, right? So, so there is some risk with also creating that type of registry. Pardon me. It's getting a little dry here, you know, all this talking, right? Has the reconciliation of cross-jurisdictional retention obligations been completed? So this is really important if you're a global organization and you have multiple laws. GDPR is trying to reach across political jurisdictions. We talked about the flow down clauses and how that works, but there may be other regions in the planet that have their own privacy legislation that also works with GDPR or works against it, or maybe the two of them, there's a superset of controls or activities that you have to follow in order to be compliant. So you need to look at cross-jurisdictional retention obligations and consent, and actually all the principles probably could apply under this category. Have practices and or standards been documented with respect to the retention of personal information? So you need to have, if you're collecting personal information, you need to have some procedures. So remember, I talked about in my pie chart, I think it was 23% are going to be you know, procedural based, right? So there's a lot of procedures. Procedures affect the front office, the back office, the support team, maybe any third parties handling personal information. So what are the practices that need to be documented or updated? when it comes to the retention of information. And again, if you have an information handling procedure, you can streamline this whole process, teach people one process, and they can learn from that and be able to address all the different scenarios around that circle of trust, right, when it comes to retention and all the other things that can happen with information. Do these standards include a minimum and maximum retention period? So that's important to identify. Principle 6 has a risk assessment that facilitated for the information asset. So it's important to do a risk assessment. You're going to look at all the vulnerabilities that could impact that information and identify the threats to that information. Any impacts on the CIA, confidentiality, integrity, or availability need to be looked at. And of course, giving some credit for the existing controls that have been implemented in the organization is always wise. If you're new to this, to the GDPR, to this information protection game, you know, a word of the wise, I've been giving you some tips here based on experience, is that you don't want to not give credit for what's already been done. And you don't want to be seen as somebody who's either new to the company or a consultant coming in, giving advice and saying that, you know what, you need to implement all of these things in order to become compliant, and not even giving them any credit at all for what they've already done, because that leaves a kind of a bad feeling with the senior management team. And it also makes them look bad to internal audit and to other groups, right? Like they haven't done anything to protect. So you need to, you know, wordsmith your risk assessment to make sure that you give them credit for what's been done. Has it been good enough? Maybe it has been at a point in time, but things have changed. So it needs to be updated now. You know, you can say something nice like that. You could say, you know, encryption is really good. Information handling is non-existent. You know, you got to find a way to balance your report so you get better buy-in and engagement with the senior management team when you present this. And again, the risk assessment supports the privacy impact assessment. So you'd really be delivering 2 reports, but you might combine it in a final presentation or something. Our regular user access, account access and privilege rights, authorized, recorded. So anybody accessing personal information probably want to have an audit log so they can record it, because if there is a problem, you want to be able to go back and to analyze it and find out what happened. Now, how long would you keep an audit log like that? That's something that you need to talk about with your organization. You know, like, is it 30 days? Is it, you know, 90 days? Is it a year? How long do you need to keep a record of who's authorized the private information? So that's, I don't think there is a really good answer out there on that. I mean, a lot of companies say 30 days, right? They want to be able to override it. But, you know, as an analyst, as an investigator, and a security manager, if there's a problem and somebody doesn't come forward on it right away, then we're kind of left hanging, trying to find out what happened if we don't have an audit log. So this is very, very important. And we're also talking about privileged access here. So there's really 2 types of access, right? So there's the people who come in through the front door, who work in the company, and they log into the business application, and they go through, you know, the policies on the network and the access control restrictions and maybe field level filtering on the application. And then you have the DBAs, right, who can actually go directly into the database and bypass the application and get direct access to the personal information or the private information. So you want to make sure that those people especially are audited, right? And they're on an audit log somewhere. And also some systems, we ran into this with Linux systems actually, and Unix systems. The system operator message queues collect everything. So sometimes when people log into your website and add stuff into their personal information, it might get recorded in one of those system logs, And because of that, you might have to encrypt those fields. And that's going to take some customized coding. So just be aware of, again, following the packet flow of the information, right, on all the hops, and check every hop to see what's there when it comes through. As the roles and responsibilities of asset owners and custodians been documented and communicated. So defining roles and responsibilities is so important, starting at the job description and all the way through, and then following up and of course auditing to make sure that people can get access to what they need to have access to only, and no more. Has an information handling practice and standard been documented for the collection of transmission, storage, and disposal of personal information? So again, another really important question when it comes to the security of that information is the information handling practice helps guide the front office and the back office to a degree, but the collection, transmission, and storage and disposal might be something that's handled by the super administrators or by the engineers or software engineers or technical engineers. So you want to make sure that whatever the information handling practices are, depending on the audience and the group of people providing support for GDPR, that it's been customized to meet that group. Right, principle number 7, accountability. It's all about governance, right? So responsibility for the organization privacy oversight has been assigned to a specific individual. Do you have a data protection officer? Do you have a privacy officer? Is it going to be general counsel that's going to be responsible? That's not always a good idea. General counsel sometimes puts themselves in a very awkward position. This is something that I've stated a few times on social media, is that general counsel is there to be one of our highest risk managers in the enterprise. They're advisors to the CEO, to the CFO, to the audit committee. Legal counsel will help keep the company out of hot water and make sure that our agreements are solid so that we don't have problems in the future. And because they play that role, they can't really have an operational role. If they become the data protection officer, now they have an operational role. So automatically, if I was a judge and a lawyer came in to defend some kind of a breach, and I learned that they were also the DPO, I'd probably say conflict of interest, right? So you can't defend your own work in a court and defend, you can defend your legal work, but you can't defend the decisions that you made around operations that led to the breach. It's just not going to work. So you'd have to hire another lawyer to defend the lawyer. So it gets a bit complex. It's easier to give the DPO responsibility to somebody who's not on the legal team, and then the legal team can do their job as the top risk managers within the organization. So that's just my opinion. That's my take on it based on experience. So I hope that's useful to you. But it doesn't need to be assigned to somebody. So you have to find somebody who's qualified to do it. Are the roles and responsibilities and reporting structure of that person documented? Do they have a job description? What will they be doing? Have performance requirements been specified in a measurable way, subject to the management reviews? So we need some kind of performance reporting on how we are complying with GDPR. How many inquiries has there been? How many customers have contacted us? How many changes have we made? Type of data that might be useful to the organization. How big is our footprint when it comes to being caretakers for personal information? Where is that information collected or stored? Do we have any exposures? You can think of a number of different metrics that might come up. I think probably the most important metric I know from a cybersecurity perspective is that whatever it is we're doing for GDPR is in support of the strategic goals and objectives for the enterprise. So if they have a 3 to 5 year plan, whatever it is that we're doing in GDPR supporting that growth. So I think that would be the most important and valuable performance metric that you could probably convey to the executives, the CEO and his team. Are independent third-party audits facilitated to review privacy practices? It's not a bad idea. Certainly in cybersecurity and privacy, we do get third parties involved a lot. For instance, when we want to make a decision about what we're going to do with personal information or how we're going to handle it, a lot of times we'll go to a third-party lawyer and we'll ask them to provide something called a legal opinion. Now, a legal opinion stands up in court. It's pretty good. And if it's a third party, it gives us a little bit of arm's length reach. So if we do practice something and it's not 100% compliant with GDPR, but we have a legal opinion that says that it is, the judge will consider it, right? So it gives us a little bit of insurance. So whenever you're not sure about what it is that you're going to do, when you do the privacy impact assessment, you discover some things that don't quite look right, then it's possible to get a third-party legal opinion that might help bridge that risk gap. So just, again, some more words of advice based on experience. Do we want someone to come in and actually do an audit of our program? And we mentioned all the different components that need to be in the key controls area. I think it's probably a good idea, especially depends on what role personal information plays in your organization. If you're a personal information company who depends on personal information to do your business, or if it's just a customer list, you have to make a decision what kind of assurance you want to provide over that. It's possible that you might combine this with some other audits, and that's more likely. You know, we have, most companies have the SSAE 18 or the ISA 3405 that they do annually, or SOC 1, 2, or 3. And these are all about trust, and they also include the word privacy. So maybe it's a SOC 2 or SOC 3 that provides that assurance over your privacy program. So that's something you might want to talk to your CFO, because traditionally those types of reports have been used by the CFO to do their annual CFO certification, which is where the CFO, if you're not familiar with it, the CFO has to certify that the financial records of the organization are in fact correct and that everything's been reported properly. So if that's the case, then maybe you can leverage that process to provide some assurance over your privacy handling. All right, data flow analysis. I mentioned this before. There's no easy way to do this. I know in the PCI world, we do use some robots, if you like, software robots, web crawlers, but we point them on the infrastructure and we have them run across the infrastructure looking for private information. So this is really useful. Mostly what I found is that the developers sometimes do not use sanitized data, and they're supposed to. If they use live data, they may be dumping spools in the test environment that contain personal information. And a spider or robot crawling across the infrastructure will probably find that. Other instances that I've seen are where people are working on maybe human resource records, and they've done a dump from the human resource system to maybe prepare a report or prepare for some kind of an annual benefit RFP going out to market to find out who can provide better benefits. And they may have a list of employees and some sensitive information on their mobile devices. So again, you might be able to discover that by doing some audits. Generally, the packet flow analysis or data flow analysis is going to hop across your environment. So from the point of where you've gathered information, it might be on a public website, it could be from a supplier or a customer, or it could be some kind of a remote user accessing your network. It's going to come across your firewall, through your switch, through your router, maybe through some load balancers inside of your organization, and maybe through an intrusion prevention system that does deep packet inspection. You have to look at all of these different appliances that are on your network in order to find out where the data hops are and find out what devices are touching the personal information and where the personal information might be viewed that might not be approved, or where it might be gathered and it might not be approved. So you need to do that analysis. So that's data flow analysis. You need to do that. And that's the end of my presentation. So if you have any questions, please bring them forward and let's chat. Okay, I see we have quite a few questions here. So where do we start? Let's start at the top. Okay.
I do have one. Probably I can just speak out for you. There's a question with asking whether there will be any difference in implementing privacy policy with regard to IaaS, that is infrastructure as service, or software as service.
Yeah, I don't think there'll be any difference, because it doesn't really, GDPR doesn't look at the technology, how you use technology to do your business. It looks at how do you comply with the law. So you need to do that analysis. You need to put on your business analyst hat and go and see where that data flows. So if you're, providing a service on the cloud or where have you, you need to do the packet flow analysis to make sure that the data is secured. That's the most important thing. I mean, the reason why you're collecting it for the purpose of the business is at the front end, and that makes sure that you're, compliant with the law. But on the back end, on the support side and the technology and the infrastructure side, you need to make sure that that security is maintained. So you'd have to go through that analysis and make that determination. Did I answer your question okay, or?
Yeah, of course, very much. And in fact, I have of my own. Probably I'll take this opportunity. I'll probably take the advantage of being host, asking a few questions. So, does this consent has to be always two-way communication? Like, say, for example, if you take up this Zoom recording, it announces saying that this particular session is being recorded, and you display your profile on the screen. Does it make it a consent from your side, or it has to be two-way communication?
That's a great question. Yeah, I never ticked any consent form, but so this is where we get into the difference between implicit and implied consent, right? So in this case, it's kind of implied because we're all participating here together. Now, the purpose, of course, is to share information. So if someone took this information and used it for something else, like to market their business or something, right? So then we might all get upset because everyone here should get a share, right?
And a couple of more, if it's okay from my side. Did you ever get an opportunity to go through the draft version of our Indian personal data protection bill? I mean, the Indian version of GDPR.
Actually, no, I didn't. So if you want to send me a link, I'd be happy to go through it and see what you've done.
Sure. I'll do it. And probably you might share, if possible, if you can share a couple of ideas, because this bill is still new for India. It hasn't been passed to Parliament, but once it is through, obviously it's going to open up a couple of opportunities. So where do you suggest to kickstart in this particular domain, like for the youngsters who are attending? What way they can probably make out most out of this particular domain, the way they get into consultancy and all.
Yeah, there's a couple different angles you can go on this, right? So you could go after those data protection officer jobs because they're going to need somebody. And I gave you a good argument why it shouldn't be the legal counsel, right? So, and I think most rational people will listen to that argument and say, he's right. You can't be general counsel and defend the company if they have problems and also be the person who's doing the operational acts side of protection. It doesn't make any sense, right? Another area, I've also provided those 4 steps. If you want to help companies become compliant, you could try and do it on your own, approach them directly, or you could maybe work with a legal team, a legal firm who's already has a Rolodex and they're already contacting companies about GDPR compliance. Maybe you can become their service provider, kind of like the way SOC 2 works, where you have somebody providing attestation, could be the legal firm, and you're providing the support on the service management side, right? Saying, here's how the program's implemented, here's how you manage that program, right?
Good, good. Thank you for that suggestion. And I was always curious about when it comes to this cross-border data flow. Does the bureaucrats work the same way like general public when it comes to data sharing, or are there any specific exceptions for the bureaucrats, especially when it's a cross-border data flow kind of thing?
Yeah, the cross-border thing, the ultimate solution are the flow down clauses where you take, because GDPR is very big on the country of origin. So wherever you gathered consent from and that person is from, and should be where the data is stored. But because we live in a connected world, it's probably not going to be. So the flow down clauses are so important when it comes to that. If you rely on political jurisdiction law, I'm afraid that, some countries are going to say, we have your personal information and we're going to go look at it. We don't care what GDPR says. Take us to court, right? So I think flow down clauses are the best way to deal with cross-border issues. You got to protect, if you're working for a big company or your own company, you need to protect yourself and you need to protect your company. And flow down clauses will give you the legal clause that you need in order to do that with. I wouldn't rely on political jurisdiction law. No.
And Mark, do you have any book of your own? Did you author any book where probably any of us can go through, or do you write articles or white papers? Do you publish those?
Yeah, I'm so busy. I don't really have any time to write. I know I talked about doing it several times and people ask me, you should capture some of this knowledge in a book and share it with people. And I hope to someday, but to be honest with you right now I have worked with ISACA on a few different publications. We did cloud, and I think we did control effectiveness. We've done a few things together, and then I've done some other things. I do have some media, I guess, links. If you like, go to secure knowledge management and you go into the index, you'll find media links in there. Hopefully they're still alive if they're not, but no book yet.
Okay. And what's your YouTube channel? Probably we can search your name. Will that get there?
Yeah, absolutely. Yeah, there's a lot of Mark Bernards in North America, and identity theft happened a few times. I mentioned I had health record identity theft, but I also had financial. So after that happened about 15 years ago, I started using my middle initial. So you'll see ES, that's Edward Sterling. But if you just search Mark ES Bernard, you should find me and nobody else, because nobody has those initials.
Sure, thank you.
Yeah,
So
you're welcome.
Yeah, thank you. And let me just call upon our CISA coordinator to offer his vote of thanks. Let's also see if anyone have any questions. Just give me a couple of seconds, Mark.
Yeah, and I was thinking about your question about what kind of business you might be able to stir up. If you master how to do privacy impact assessments, I think I know here in North America they're always looking for PIA writers, right? So I think privacy impact assessment hasn't really gone on with GDPR, but I'm pretty sure it will after a few years, because the current evaluation process they have is not very good. So if you learn how to do PIAs, it might be a contract opportunity for you.
Great, Mark. Thanks for that.
You're welcome.
Yeah, and hoping no further questions. Most of the people, they were probably they're congratulating for the kind of session, and they're very happy with the session, the way you've taken through. In fact, for me, it was a little surprise. So detailed kind of session could be accommodated within 2 hours. That's really great of you. Yeah, there's one more question, if it is okay with you.
Yep. Go ahead.
Is it mandatory to have data protection officer in the organization?
Yeah, it is. Yeah.
Okay.
Yeah, some legislations demand certain roles, and the GDPR looks for a DPO. It has to be assigned to somebody. Yeah.
Okay, great. And there's another question. It says, can you please explain again about hiring a lawyer to defend general counsel who may be acting as DPO? About hiring a lawyer to defend general counsel.
Oh, yeah. Well, it's the bottom line is it's conflict of interest. So the way lawyer works is they help define the policies around, a lot of it's around risk management, to be honest with you. It's very, it is legal based, but it's risk management because the way that they write clauses and the way that they obfuscate the legal verbiage that's in the master services agreements and the articles, the way they do that, it's on purpose to protect the organization that they work for, right? But if there is ever a breach, the first person that's probably going to be, going to court will be the general counselor, right? To protect. They might hire a third-party lawyer. It's possible to do that. A little bit of arm's length reach, but they're going to go to court and they're going to defend, their policies of their organization and how they handle information and that sort of stuff. But if the judge happens to say, okay, well, can you bring the DPO here because we also want to ask the DPO what they did, and they say, oh, I'm the DPO. Well, there's a conflict of interest because DPO is an operational role, and being on the legal team is not. It's an executive. It's you're providing legal expertise to the president, to the CEO, and to the executive team on legal matters, which makes you an advisor, like a trusted advisor within the organization. So that's not really an operational role, being an advisor, but certainly DPO is an advisor because you're going to be working with all the managers in the organization. You're going to be making sure that they have the security controls in place. You're going to be reviewing the policies that they write. You're going to be dealing with external inquiries that come into the organization, right, about your handling practices or about the right to be forgotten. So you're going to be dealing with a lot of operational stuff, and that you just can't defend in court your own work. You need to have somebody else do that, and that has to be, and hopefully it's your general counselor. But yeah, so it could be a conflict of interest. Does that help explain it?
Yeah, of course, very much. Thank you.
Okay, you're welcome.
So probably I think that's it for questions. Now I request Mr. Leeladhar, our CISA coordinator of Hyderabad branch, to give his vote of thanks for your time, for your kind of great session, what we had so far. Leeladhar, please request you to please take over.
Thank you, Mark, for the excellent session. We have clarified a lot of doubts of the chapter members, and also you have given a lot of insights into new things, and it was a great learning session. Thank you so much for sparing your time, valuable time, and this odd hour for you. Canada, it's an odd hour for you, but for us in India, it's a normal thing. So thank you once again very much from the Hyderabad chapter. Thanks to all the participants for having patiently listening to the beautiful lecture of Mark. Thanks once again.
Very welcome. It's a pleasure to be here. Again, I have so many Indian friends. I've never actually had a chance to speak at an Indian chapter, and this was a great opportunity. That's why I jumped on it. I hope you all are taking care. Pandemic is raging outside. So take care of yourselves, and we'll talk again soon.
Sure. Thanks, and hope to see you soon.
Yeah.
Some session.
So, you'd like to have more sessions from you, Mark?
Yeah, if you want to arrange more conversations, I'm sure the ISACA management team would love to set that up. I'm open to the idea. I think it's good. I believe in good karma. I think if we do good deeds, they'll come back to us. So
yeah,
I'm open to sharing with my colleagues and hopefully help you to find a good path that you can follow.
Thank you, Mark. That's kind words.
Thank you.
You're welcome.
Take care.
Bye for now.